People v. Thomas.
May it please the court. Good afternoon, Your Honors. Mr. Bloom, my name is John Casey. I represent Kevin Thomas. What I'm asking the court in this argument is to analyze this case using the DeBoer factors for this police encounter. And I believe in the court reviews the body cam video and the testimony. The court will find that there was never at any point any reasonable suspicion to detain Mr. Thomas during that 40 minutes.
Mr. Casey, let me just interrupt you for a second.
Yes.
Do you wish to reserve any time for rebuttal?
Oh, I'm sorry, 1 minute, Your Honor, thank you. And I think it's clear also from the video and the testimony that the reason for the traffic stop, running the stop sign, ended very early. In fact, it was over about...
So here,
Yes.
the Supreme Court, the Suppression Court, and the Appellate Division applied founded suspicion rather than reasonable suspicion. Was that the right standard?
Correct. I think it was the right standard in analyzing whether they could ask pointed questions to Mr. Thomas.
So you would disagree that that reasonable suspicion was perhaps the proper standard instead? And that wasn't used here?
That's true. I believe under the Court of Appeals decisions. that
Well,
it
counsel,
wasn't.
to add on to that question, you also argue in your brief that there was an absence of a founded suspicion to search the car or to prolong the stop. So is this a change from what you were arguing in your brief?
I think it is somewhat of a change. It's not, if I can explain a little bit as how this developed. When they can question somebody with, they can question a defendant if they have founded suspicion that criminal activity is ongoing. The officers did that here because he started lying to them about where he had been. And they knew where he had been because they had a fellow officer tell them. So they used that to ask him pointed questions. What we had argued below and had argued all along was that once the traffic stop justification ended, which was before that, they couldn't even start asking about the parole issues and where he was coming from because all that came after the stop sign issue was resolved and the...
Well, let me ask you this. So the officer gets a communication that the defendant is out of state, out of the county. The officer observes him come off the ramp.
Correct.
Put aside anything that the defendant actually said. Assuming for one moment that's enough for the officer to suspect that there's a violation of the parole, that he's gone outside, the inference that he's gone outside of the county,
Correct.
probably a condition of his parole. Could he have called the parole officer at that point and just detained the defendant while he's waiting for the parole officer to arrive?
That's an interesting question. I think he could have called the parole officer
Yeah.
and asked him and confirmed, and this is an important point, confirmed that there was an actual parole violation because at that point he could have had permission. They didn't do that. Whether he could do that, that's an interesting question. It didn't happen here because they didn't call the parole officer, in fact. And
Well, they did. No, he did.
Later, correct. Your Honor.
Later.
They did later, but
Later.
They-
Well, I guess I have a question about,
Yeah.
let's assume that everybody agrees that the stop, having gone through the stop sign, excuse me, the detention having gone through the stop sign was valid,
correct.
right? No one's objecting to that. And there was no reason not to ask him, if I can use double negative, for his license, registration, all of that. No one's disputing that was improper. Okay.
Yeah, pertains to
All
the
right.
stop.
I don't think anyone's disputing that, well, maybe you are, I'll ask. You're disputing that he couldn't ask for consent to search the car.
We're disputing.
Could he ask?
that he could not because the justification for the stop had ended by the time he started to question him to develop. If he developed a founded suspicion, it was after the justification for the stop. And the appellate divisions in this court are all clear that once the justification for the stop is concluded, you can't, after the fact, develop reasons to continue the detention.
So is your argument that at the point that the time that justified the stop ended, when there was no longer any purpose for the stop based on a violation of the VTL, there was neither a founded suspicion that would justify a request to search or moreover, a reasonable suspicion that would justify any even more intrusive?
Correct. And now, if this court decides that, well, because the parole was ongoing, and you find that it was okay for the officer to just ask him, hey, where were you coming from, even though the traffic stop was over, at best, the people may have developed a founded suspicion. And I think that's what they argue, which would allow them to ask him under the Court of Appeals to search a vehicle, and even to get a dog, to sniff the vehicle. However, the important distinction here that I believe the difference between the Court of Appeals and the appellate divisions is the Court of Appeals has unequivocally stated that to detain the defendant, not just to ask him questions, and not just to get a dog to come to sniff the car while the stop is still valid, but to detain him, there needs to be reasonable suspicion. And I would submit that when the court looks at this, Mr. Thomas was detained the entire time.
Is the calculus modified in any way by the fact that they know that they're dealing with a parolee at the time? Does that count to enhance their suspicion, or does it change anything at all? And I'll ask you part B of that question, is they're asking him some questions. I don't know exactly where in the transaction it is, but they're asking him some questions that they are reasonably sure that he's giving false answers to. How does that factor in here?
Well, first, all of that, again, came after the fact. So they didn't have.
So because they didn't ask any of those questions, by the time the purpose for the traffic stop had expired, it's all gone?
Don't they know because of the call before the traffic stop that they have reason to believe he is violating his parole? Or am I misunderstanding the record?
They did have reason based upon the call from their fellow officer that he was outside the jurisdiction. They knew he was on parole. So they had suspicion that he might be in violation of his parole, which at that point they never confirmed until later with his parole.
So what, if anything, flows from that suspicion that he's violating his parole?
I haven't found, have not seen a case from the Court of Appeals that have said a reasonable suspicion or founded suspicion that he's violated parole allows the police to detain an individual.
But counsel, to follow up on that, though, we have Huntley, right? And to me, this is the lens of Huntley, this case. So in Huntley, we have a search by a police officer and a search by the parole officer. Different standards, right? We lay that out. The cases you cite, some of them, they don't involve parolees, which I think changes the analysis somewhat here. So to Judge Halligan's point, when they pull over the defendant, they know he's a parolee and they have this information that he may have violated, and that informs this interaction from that point forward under the Huntley analysis. So whatever standards they are, reasonable suspicion, probable cause, whatever the standards are that we've laid out for police interactions are now affected by the parolee's status. That's what we said in Huntley, and that's what we said in McMillan. Later on, and we haven't talked about it much, by the time you get to the parolee search of, the parole officer's search of the car, different standard, right? Different standard under Huntley. But this part which we've been going back and forth at, I would like to get your thoughts on how does the McMillan-Huntley, it's always relevant that you're dealing with a parolee, even when the requirement is probable cause, it's McMillan and Huntley. How does that affect the Rodriguez analysis, the reasonable cause analysis? How does that status affect how we should view that?
I think here, it is always relevant, But here, even with the information that the police officers had, they only had a level of suspicion that he was in violation of his parole. Now, if it was just that, could they hold him there and say, we're going to hold you here and call your parole officer and see what tell him that we've got you and see if there's a violation of parole?
That's an important question that I think Judge Rivera asked before, and I wasn't sure we got an answer.
What happened is by the time they did that, they had detained him.
Yeah, no, but let's deal with this hypothetically. Suppose he hadn't run the traffic stop at all, the stop sign, right? So they have the information they have, and let's even put aside the question of whether they could stop his car. Let's suppose all they do is they follow him to his home, he parks his car in his driveway, he gets out. At that point, can they ask him questions?
Yeah, they have an objective reason.
So at
they
that
have an
point,
objective to question him.
can they detain him to wait for the parole officer to come? That's the hard question.
I don't believe they can. I believe at that point, he could say to them, I'm not answering any of your questions, and he could go inside. If they tried to detain him, I think it would be improper at that point. I think that they would have every right to call his parole officer and say, we've got your guy here, he just went in the house, or they could, if he drove away, I think they could follow him. Again, none of this happened.
So they
but-
couldn't detain him, even though, let's assume for purposes of this question, their suspicions are that his parole violation is having left the county in his car,
Right.
and fear that that might be replicated. Maybe he'll abscond because the violation might lead to his being brought back into custody, right?
Right. So let's assume that would be completely proper for them to call at that time and say, I'm going to detain him till you get here, and then the parole officer comes down. Maybe if the court were to find that was fine, at that point, the parole officer comes, all of this questioning and the detention and them holding him, the parole officer is going to get there, and then the parole officer can do his own investigation, whether
they-
that would have led to the car
Could they hold
search.
him without a parole violation warrant? Just on a suspicion? Or are you saying the oral communication, saying, yes, if you found him outside of, it is an actual violation? Is that oral communication enough?
I think then it would go to the reasonableness, how long can they stay with him and hold him till the parole officer gets here? And
Parole officer could have arrested, correct? If he was on scene and he thought that he violated his conditions of parole.
I believe so.
What if when he called the parole officer, the
Yeah.
parole officer said, hold him, I'm on my way. Don't let him leave.
Well, we would have a different case then.
Yeah, I know that's the point. That is the point of the hypothetical.
But could he do that?
I think then they could at least say, well, our basis for holding him was because the parole officer confirmed for us he was in violation of his parole. And
So is it your view, I'm still not sure I understand the answer to the chief's prior question. If he has pulled up in front of a house, and because of the prior conversation, the officer has reason to believe that he is or has violated his parole, and he's going to get in the car and drive off, can they hold him while they reach out to his parole officer and ask what the parole officer, how the parole officer would like them to proceed? Or are they required to let him drive off and relegated to simply following him?
I don't know the answer to that question. I would just say here,
But isn't that
police-
essentially?
I'm sorry,
What-
Judge, I'm sorry.
No, go ahead.
The police were not, the police were holding him to try to search his car, and they weren't holding him there necessarily for a parole violation.
And if we thought that they were holding him for a parole violation initially with the initial questions, then is your answer to that it's unclear to you whether they had the authority to do that?
Well, I think the people's position is that this escalated to the point where they could request to search the car, and that then at some point it became, I believe they're saying reasonable suspicion.
I took it that your position, I'm sorry, I realized the red light is on. Can I just quickly wrap
yes.
up? I thought your position was that once the license check came back, that there was no basis to ask any further questions. Is that
That is
correct?
our position.
Okay, and so my question is, if the prior communication gave, between the two officers, gave the officer who stopped your client reason to believe that he had violated his parole, is it your position that they could not hold him, not to search the car, but to ask the parole officer how they might want to proceed, or were they required, notwithstanding the basis to think he might be violating parole, to let him drive off?
I think they would have to, I understand now, they would have to call the parole officer, and I don't believe,
Can they
I don't
ask
believe
him-
they could hold him. I don't
Okay,
believe they could.
so once the license check is clean, they can't hold him while they call the parole officer? That's your position?
Correct.
Okay, thank you.
Let me ask you one more variation. Same, exactly the same, except instead of holding him, they simply block the driveway. Can they do that?
I believe that would be a detention of him in some
Even if he
sorts.
could walk off to wherever, or call an Uber?
Can I just ask one more variation? What if they called the parole officer just to ask him to get a violation warrant? What, you know, we found this guy, we think he was violating parole, because it was after hours, right? He was past curfew, so that in itself, could they hold him long enough to make that call?
I think it would have had to been done in the context of the stop for the rolling through the stop sign, and they would have had to question him about where he was coming from and about his parole during then, and then say, well, let's just call your parole officer now to see if you did have permission, and that would be a different situation, and that might justify the limited detention from the initial stop to continue for that part of time. But once that was expired, I believe they've got to just, they could keep an eye on him, I guess they could wait right down the street, they could wait on the street, they could call, but I don't think they can hold him and detain him at the scene and make him not leave and go in his house or even drive away. They had plenty of opportunity to do that for an hour before they even stopped him, because they had noticed that he was possibly in violation of his parole. So I just don't think they should be given the benefit now of doing something that they didn't do in the first place, because they weren't really interested.
So the officer has gotten information from another officer, again, getting back to the hypothetical, that it appears, that at least it's a reasonable inference, that he may have violated a parole condition of not leaving the county.
Right.
Right, the other officer, I think there's a suspicion about drugs too, but let's just stay with this one, right? Tells him, keep an eye on him, and that's what the officer's doing. He watches him get off the ramp, he follows him. In the course of this, he sees the violation of going through the stop sign. So I don't think that vitiates the other suspicions they had, and the other reason he was observing the defendant. So he's resolving one, but it doesn't in any way vitiate the other suspicion, right?
Well, right, it doesn't, but
The other basis
what
to observe, and that's what he.
what the police can do with
if he
that
hadn't gone-
suspicion is call
I don't
the
remember if
parole
we
officer.
asked this one, if he had gone through the stop sign,
Yeah.
but suspected the violation, could he go up to him and talk to him at all?
Oh, sure, they could approach him, but they can't detain him. If he says to them, I don't want to answer the
Understand.
questions, even if he lies to them, okay, well, they can call his parole officer and they can sit there until the parole officer comes down, and then the parole officer can take over. We don't know, I don't know there doesn't appear to be a standard articulated from this court as to what the police can do with a parole violation, a suspected parole violation when there's not a parole warrant issued. And I would suggest that the board does not allow them to detain him. And in this case, that's why the drug should be suppressed, because the ultimate search came from that unlawful detention. Thank you.
Thank you.
Good afternoon. Nathan Bloom for the Chemung County DA's office. May it please the court. Faced with a series of important questions about Mr. Thomas's behavior, Officer Linehan did his job as a police officer by seeking answers to those questions in a way that was reasonable and constitutional. Parole Officer
Can I
Pirozzolo,
ask you, if we find that the detention extended too long or was unlawful, does it necessarily flow that the search by the parole officer that recovered illegal substances was invalid?
no, I think that would go to our secondary argument, that at a minimum, they had probable cause of a parole violation, which constitutionally would give them grounds to, in fact, arrest him, so certainly to detain him, so anything that would flow from that
Well, they
detention.
couldn't arrest him, right? They had to wait for their own parole, his parole officer could arrest him, but I believe the police would have to get a warrant to
Well,
make that.
Under New York State statutory law. Constitutionally, they could arrest him, and this is based on, I cite the cases of Dyla from the Second Department and Bernasset from the Second Circuit, obviously just persuasive before this court, but they lay out in detail why it's not a constitutional violation if they arrest him even without a warrant based on probable cause of a parole violation. So even under those circumstances, a detention would be.
How long can they hold him to find out if he violated parole? After they've completed their work for the original stop?
I don't know that there's an exact time period, obviously. Obviously, at a certain point, it would become an arrest, and they would need more than reasonable suspicion. They'd need probable cause. But here, there was no indication that the record that he was detained unduly. In fact, one thing we know from the record,
Well, what do you mean by unduly?
I
In
think
terms
there's at
of
least.
duration, you mean, or without?
Yes, in terms of the duration.
Well, seemed like a long time from the video.
Yes, at least in the video, they're 20 minutes. I don't think that.
Were they
that's so-
done with the ticket at that point?
I think he's done with the ticket very quickly, I think, after a
And
couple
when
minutes.
he's done with the ticket, why does he have the right to have him sit there until he can figure out if maybe he violated parole?
Well, I think this gets to a point that Judge Rivera made earlier, that when the officers approach Mr. Thomas initially, there are two separate and distinct bases for a police encounter. Of course, you have the stop sign infraction, but you also have an independent basis for a level 1 interaction, which is the fact that he's a parolee who's been seen outside his restricted area.
So are the police required to separate that out and treat it as two distinct reasons? I guess that's what I'm grappling with. Is there a continuum, or can both of those things happen simultaneously? They're dealing with the traffic infraction, and they also have this information that he's a parole violator based on their fellow officer seeing him outside the jurisdiction.
Yes, I think either way, we would be fine. I think whether it happened under the chief judge's hypothetical, if he had stopped at the stop sign and they had simply.
But at that point, even if they know he's on parole, and a police officer says, I know he's on lifetime parole, I know he's outside of the jurisdiction, at that point, is it clear that he was in violation, that he didn't have, in fact, permission from his parole officer to be out? You don't find that out until you actually contact parole.
Correct. When they initiate the traffic stop, they don't know for sure yet whether he's violated parole.
Correct. So how long can they hold him until they can find out all of that, if there is an actual
Well,
violation?
I think we go up the DeBoer ladder at this point. I think initially, once the traffic stop portion is concluded, they have basis for a level 1 interaction, just to ask him, at a minimum, where are you coming from? Then they have founded suspicion once he starts enmeshing himself in this web of lies. And then reasonable suspicion once, and to go back to your question about when we know he's violating parole, I think almost immediately we see probable cause that he's violated his parole when he's asked, because there are two violations here. There's leaving the county without permission, and there's also the curfew violation.
Yeah, the problem there maybe is that you start with level 1, I guess, when you just ask him questions, but the point you're doing that, he is, I think, sort of detained for a different reason, right? So it's almost like you're shoehorning level 2, even though analytically you should be starting at level 1, based on the traffic stop.
I think you can carve out the traffic stop. I think the traffic stop portion ends as soon as In the video, you
Well, it
can,
ends before the video, I think, right?
when he asks about, who's your parole officer and all that.
No, I think that with the video, at least as I recall it, the traffic stop is over by the time the video starts. We don't see the traffic stop on the video.
Correct, correct. I mean, addressing the issue of the license and registration, that goes on for a couple minutes. And then at a certain point, you see Mr. Thomas calling out to someone at his house, do you have the documents?
Well, the
And-
officer's saying, I don't want the license registration.
Yeah, and I think at that point, traffic stop portion is concluded. We have pretty much a separate interaction that could have occurred without the traffic stop at all, just a level one interaction.
But at that point, don't you think he believes he's detained? He's not free to walk away?
No, I
So
think.
he knows the traffic stop is over at that point, you think?
I think there's at least evidence in the record. Once the officer says to him, don't worry about that, plus the fact that they've been having a very casual conversation up to this point. They clearly know each other. They've just been shooting the breeze. It's still a very casual interaction. I don't know that we
He's
can say.
asking for permission to go to the house to get the, can I walk over to the house, right? So he doesn't think thinks there's some authority.
Yes, but I think just because he's being agreeable in that instance doesn't mean a reasonable person would for sure say that he's not free to leave.
Does it matter that he's pulled into his driveway? Does that factor at all into the analysis?
I don't think so, except maybe to the extent that it would put him more at ease, that he's kind of at his home base. That's all I can think of right off the top of my head. Otherwise, I don't know that it's particularly relevant that he's pulled into his house. This could have happened anywhere else, and I think the analysis would be substantially similar.
Can we go back to the line of questioning Judge Singas was pursuing about the two things that are going on at the same time? Are you actually saying that if they had a reasonable suspicion or even probable cause to believe that he had violated his parole, they could detain him or even arrest him at that point?
Constitutionally, they can arrest based on probable cause of a parole violation.
And what do you mean exactly when you say constitutionally?
That it's not a Fourth Amendment violation, and I don't believe it's a violation of New York constitutional law
Great.
either.
So then let's get to the second issue, which is the evidence that is sought to be suppressed here. That cause, that reason for arresting him for a now probable cause parole violation in no way affects the officer's right to somehow effectuate a search of the vehicle, right?
Correct.
So with respect to the constitutional perspective of whether they were allowed to detain him for a search of the vehicle while waiting for the parole officer to come, where do we put that? Do we allocate that detention towards the parole violation or towards the search of the vehicle?
I think if I understand your question properly, I think it's independent of the search of the vehicle. I think that's solely based on the parole officer's authority.
It's really confusing because there's two separate things going on, but
Yes.
my impression, my sense of what was happening at the time was that they were holding him to give the parole officer an opportunity to come to the scene to see if the parole officer wanted to make an inquiry, search the car, do any of the things that I'm sure you would argue the parole officer has total right to do. So to me, the detention is related to the search and not to a parole violation.
Yes, but I would say that their subjective motivation in holding him over shouldn't be relevant to the analysis, especially when
Well, does it matter whether we think the police are working for the parole officer or the parole officer is working for the police? Does that matter analytically?
Well, certainly, the police can't be using the parole officer as a conduit for their own agenda.
Right, and if you watch the video, the police, well, tell me, let me go say a few things and stop me if you think I'm mischaracterizing anything. The police did not believe they could search the vehicle themselves,
Correct.
and you think that's correct? They couldn't?
Yeah,
Okay. The police wanted to search the vehicle.
yes,
The police, before trying to contact the parole officer, tried to get a drug sniffing dog.
yes,
And had they gotten a drug sniffing dog and the dog alerted, they would have then had probable cause to search the vehicle.
yes.
They were unable to get a police dog. after that, they contacted the parole officer.
Yeah.
So does the record support the proposition that the search by the police officer, by the parole officer was really at the behest of the police?
Well, I think there's no question, part of the police officer's motivation in calling the parole officer, as the appellate division said, was because they want to get into the car to possibly find drugs. I
And
think,
they couldn't get a dog?
Right.
Couldn't find some other way around other
From
than
their
getting a-
perspective,
yeah.
to some extent,
Yeah.
the parole officer is a dog substitute, from their subjective perspective. But I would argue, even if that were their entire motivation, the question under Huntley is not the police officers, what the police officers are thinking, what their subjective intentions are. The question is, when the parole officer arrives, what is he doing? Whose duty is he fulfilling? The question being under Huntley, is it substantially related to the performance of his duty?
So theoretically, the parole officer could have arrived at the scene and said, no, I don't feel like I need to search the vehicle.
And the police officers would be bound, I think, by that decision. Now, to take a hypothetical perhaps, let's say the parole officer said, you know what, I don't think it's in my interest as a parole officer to search the car. I think even then you could argue that a subsequent search by the parole officer would be permissible because objectively there were parole grounds to search the car, the fact that the car was used to commit a parole violation.
Yeah,
And-
which sort of makes you wonder why, when the police officers in Pennsylvania reports that this guy is in Pennsylvania, the first thing isn't to call to the parole officer. Because then there's plenty of time for the parole officer to figure out what to do.
Yes, I do think there are two explanations for that. One is that they don't know where he's going to end up. For all I know, he could go way past Elmira somewhere else. They don't know that it's worth rousing the parole officer after 9 o'clock on a Friday night. They also aren't sure whether there's even, at this point, they're not sure whether there's a
Geography's
parole.
not very good, I guess, but how far is Pennsylvania from Elmira?
I think at the point he spotted, it's about an hour and a half roughly
And
from,
he stopped at 9:35, so it's 8 o'clock when they see him, so it's not that late.
right. I think that's one possible motivation. Another motivation is, they're not sure yet whether there's even a parole violation at all. For all they know, he has a travel pass. Although they
Can't
discover
figure
very
that
quickly.
out without asking the parole officer, can they?
Well, even with that,
I mean, that cuts against your reasonable suspicion, I think.
yes, and I think
Look,
it's
the
all,
officer in Pennsylvania is off duty. He calls an officer who's on duty. I think the real question is, why does that officer delay calling a parole officer at that point and instead follow the directive of the officer who's off duty in Pennsylvania who says, keep an eye on him? I think the
Yeah.
motivation is not, the record seems to suggest the motivation is not the parole violation. Motivation
I
is,
think-
because what's a nice way of putting this? He's someone with whom the police are familiar when it comes to narcotic
Correct.
sales, if I can be so generous.
and
so
that's
perhaps
true.
that's what's really motivating this. On a Friday night at 8 o'clock.
quite possibly, but I'd say that that's not dispositive. The question is an objective standard when the parole officer arrives. And of course, the police officer's subjective motivation may be circumstantial evidence of whether the parole officer really thought that he was doing his duty as a parole officer when he searched the car, or whether he was in fact doing it at the behest of the police, but that credibility determination was for the trial.
Well, the
courts.
parole officer understood that the defendant was being detained.
Yes,
So the parole officer understood that the officers are waiting for the parole officer's arrival to do something. Can't be to do nothing.
yes, and that's a factor, but there's still certainly evidence of the record to support the proposition that it was for legitimate parole purposes that he's searching the car, because it was used to commit the parole violation and because it contained evidence of a technical parole violation in plain view. that
The
police-
receipts or the packaging,
Yeah, the food packaging.
the receipt was in the wallet, yeah, okay.
and
Well, I guess you can't unring that bell, right? Like, he's the parole officer, and if his parole is violated, he needs to act on that.
well, he doesn't need to, but I think he has legitimate grounds.
And that's his job, right?
Yeah,
as a
I think
parole
he
officer?
should. I think he should at that point.
Do you have any, can we just switch gears a little bit? Any concerns about the standards that were used below, founded suspicion versus reasonable suspicion? Are we bound by one or the other? What are your
Yes,
thoughts on
and
that?
I did notice that the courts below may have conflated founded suspicion with reasonable suspicion. I think,
But they said founded suspicion, right?
yes, I think there was also reasonable suspicion very quickly as well. I think even before the 6-minute mark in the video, as soon as the defendant gets to his third lie, that he just came from Rochester.
Oh, you're saying that would give rise to a reasonable suspicion?
Yeah, so we do get to reason.
But those aren't, that's not the finding made in
No.
the suppression court.
I don't know. I
So
think
if they didn't
certainly,
review it based on the right standard, doesn't it have to go back to have them do that?
I would have to, I don't know, I would have to review it more carefully, obviously, to make sure.
Well, do you think we could make that finding independently, that there was reasonable suspicion? On a mixed question of fact
On a mixed
and law?
question, all you need is evidence in the record to support the proposition that there was reasonable suspicion.
But you need record evidence to support the finding, but the only finding was founded
Well,
suspicion.
There was also something else.
We'd have to make our own independent finding of reasonable
There was
suspicion.
also something else. You could rely on my secondary argument about that there was at least probable cause to arrest for the parole violation constitutionally, even though under statutory law they needed a warrant, because the
But I don't
judge-
know, but I still don't, maybe you tried to explain this to me before and I didn't understand it. I don't know what the probable cause to arrest for the parole violation does in terms of giving you a justification to search.
It doesn't to search, it does to arrest and therefore hold him until the parole officer arrives and searches for his own independent reasons. So it gets you to the parole officer's independent basis for a search. The fact that the defendant was on parole as being a basis for the detention is something that the trial court said it explicitly in its decision. It said both because of founded suspicion of criminality and because of independent circumstances of the parole violation, they each gave grounds to detain him. So that's certainly, I would have to review about the reasonable suspicion issue, but certainly that is cited explicitly in the trial court's decision.
Thank you.
Thank you.
Just on the point of their secondary argument, I believe by the time he stopped, any parole violations of being out of the jurisdiction or beyond his curfew were completed. So it's not an ongoing violation at that point. It's done. In addition, I would argue that the record will reflect that if there was probable cause to detain or probable cause of a parole violation, it wasn't developed until too long into that detention that would make the development of that illegal, because he shouldn't have been detained to the point where they got to talk to the parole officer to confirm, yeah, that he actually did violate it, and now you can come
Counsel,
down.
where do you stand on a police arrest for a parole violation? Is that possible?
I think they gotta have, they have to have the parole officer involved at a minimum. I'm not sure, I'm not really sure.
A
but-
violation warrant or something? Can they just say, we figured out, we've deduced that you have violated your parole, so you are now under arrest? I don't know the answer to that, which is what, can that happen?
Judge, I don't either, but I don't think, even if it could, that in this case, it's permissible for them to rely on that now. That's all I can answer.
Counsel, could I just ask quickly a variation on the facts that were set out by the chief judge about this case? Suppose all the things that happened here happened, they see this person, but they they think there are drugs in the car, they want to get in the car, they call for a dog as they're pulling the guy over, they contact a parole officer. When they get to the car and they're still in the midst of the traffic stop, they ask if they can search and assume they have a basis for doing that. They ask if they can search. So nothing illegal has happened to this point, but clearly the officers want to get in the car. Then the parole officer shows up while that stop is still legit, no Rodriguez problem. Would you still have a problem because the parole officer is acting to fulfill the mission of the police, who clearly want to get in the car, or do you need the predicate violation of the illegal detention?
I think at that point, it's police, one, Mr. Thomas 0. I think they win. I think they win there.
Fair enough.
But again, and I think
I
they
understand.
could have.
That's not what
I think it was good police work. They just, it didn't follow the DeBoer.
No, I understand.
That's it. Thank you.
Thank you.